this very disturbing. This threatening with a firearm, threatening to kill, punching in the head, choking. My God. Once you do something, you break through the barrier and you do an act, you're capable of doing it the same act again, no matter what you want to say.
I want the truth. You can't handle the truth.
Mr. Rogers is charged in 24 CR 1697, aggravated assault with a deadly weapon, and you were facing up to 20 years in prison in this case.
Your Honor, if we get him one more time, we're working on trying to get him in the Veterans Court. He's a veteran, and I believe this qualifies for that. So if we get some more time, we can get that taken care of.
All right, who is Charletha Rogers?
My wife.
Okay. Where does she live?
3545 Richmond.
Is that where you live too?
Yes, sir. That's my address.
Well, he's not staying there, Your Honor. That's his address.
Well, that's what he just said.
Well,
That's where
I
said living. What does that mean? How can you live and not stay?
He's not talking about that. He's been living with his mother.
Are you having any contact with the lady?
Yes, sir. We have
Yeah.
been talking and we've been going to marriage counseling with through the CPS caseworker.
Oh, okay.
As well.
Somebody didn't tell him about a bond condition? In every case, you cannot have any contact with the victim of the offense. If you're doing that, your bond is revoked. You stay in jail until this thing gets done. But the bondsman told you that. You've got the bond conditions are normal for everybody. It's the same, no matter who the victim is. If it's your wife, tough. Y'all got to separate until this can get resolved. You're not supposed to assault anybody, much less a wife, but you can't have contact with the victim. Why are you looking like nobody? Your attorney didn't tell you this?
I understand it, but
Your bondsman didn't tell you this? Of course they would have.
the bondsman told me that the protective order took precedence over the.
I don't care what, not in my court.
Yes, sir.
Protective order doesn't bind me. This is my order. It has its effect. Protective order, I don't care. What's the protective order say? Not to have any contact with it?
Protective
Well, what
order
are you doing? You're breaking two orders?
Your Honor, the protective order stated for me not to go in 200 yards on my wife or the children, but the protective order lost its effective date on October the 1st. The CPS caseworker asked her if she wanted to extend the protective order.
Okay.
She told him no.
Okay, that doesn't matter to me. My order stands. It's the same order that's in every case. I'm sorry, aggravated assault with a deadly weapon. If you happen to, once you do something, you break through the barrier and you do an act, you're capable of doing it the same act again, no matter what you want to say. You shouldn't have done it the first time. If you did, you're presumed innocent. I don't care. The point is the grand jury thinks otherwise.
Yes, sir.
They heard evidence and probably you committed the crime. That's probable cause to indict. But the point is we separate the victims. If it happened again, twice, it would be on my watch. Yeah, people would ask me.
It won't happen again, Judge.
You know what? If I would have asked you the day before you were accused of this, if you'd be charged with a crime like this, what would you have told me?
I'm not sure.
Oh, really? I can tell you what I'd say. Because I'm pretty certain about my actions. I mean, assaulting someone is pretty clearly wrong. And I can tell you, I wouldn't do it. I've never done it. But the point is we separate people. My court order is you don't have any contact with it. I find you do. I find out you do. This should have been told to you, and I'm aggravated about it because this shouldn't happen. Because if something happened now, I'd be the one going, you're not policing your orders, are you?
The reason why.
You know what? Failure is not an option. There is no reason.
The reason why.
There is no reason. My order stands, sir. Do not have any contact with this lady. And that's the order for everyone who has victims in their indictments. They have to stay apart until we can resolve this. Because it's happened before and it's in before people have gone right back and assaulted the same person again. And then they go, how could this happen? If the court was policing his order properly. And these orders are the same These are the same bond conditions in every case. It's not my special order. The judges all use the same standardized bond conditions. And one of those is don't have any contact with the victim until we can resolve this. You got to figure it out. Either you leave or she leaves. I don't want it. And I'm going to check on it. May have somebody drive by every day if I have to find out if you're violating the order. You do, you'll sit in jail. Your bond will be revoked. You'll sit in jail until we can get around to resolving this, which sometimes takes years.
That's hard to do.
Sir,
That's hard to do. I mean, the reason why I'm saying that is because
you got to figure it out, sir. Well, just like every defendant has to figure you got a problem, fix it. You got an attorney, work with your attorney. That's what he's paid for, is to help you resolve this. Everybody makes mistakes. And you're presumed innocent. We're not saying you did. You're charged with making a mistake. If you made a mistake, fix it. Fix it. Yeah, people make mistakes, but number one, you fix it. Number two, you don't do it again. Okay. But you got 24 hours you got to work with him.
I'll talk to him about that, Your Honor.
I mean, that's serious. Because we've had situations where partners, married people,
I wish
partners came up here. We had an assault and they went right back, got together, and someone was killed. And then it was who's to blame then? Bondsman, and most importantly, the person who does the act. But this is to separate time out, get everything fixed up so we can get back in the game of life. It's in everybody's best interest. But and then a lot of times we find out a lot of times in these partnership things that people are threatened, they're intimidated, that they're back together. They're not supposed to be, but one or the other feels like they didn't have a choice. They're pressured into it. And that really makes me angry. Then wrath comes down because all kinds of problems develop that need to be fixed quickly when that happens. Because I don't want victims feeling like they're to blame. That's needs to get fixed. How long have y'all been married?
Going on 4 years. Been together for 9 years, going on 9 years.
You got a copy of this,
I've
don't
seen all
you?
this area.
This is one of the more disturbing probable
Well-
cause affidavits, the most threatening thing I've heard, between threatening with a gun, punching, hitting.
Your Honor, that's one of the reasons I was trying to get him in the Veterans Court, because a lot of this relates to his.
When was that going to happen, John? He's staying with the victim.
I know I'm gonna work on that to get him out
You
of that.
think? It's got to be done today, something.
But he's
My
getting
goodness.
treatment to the VA's office right now, VA's medical.
Oh, I'm gonna say, while we're getting around to doing it, look, this was indicted August. How much time has to lapse before the rules are followed? Come on.
I'm gonna talk to him about that to make sure he follows the rule, because he was following the rules.
And I want to know who's going to accept responsibility if something bad happens. Is it you? I just found out about that. Y'all have to be knowing. State, what are you going to do about it? We got a violation of condition of bond that's being violated here. And I mean, this is threatening with a firearm, threatening to kill, punching in the head, choking. My God, that's what this all says. And we're lackadaisical about separating this?
No,
and
sir. We've
making
asked
sure
for
that
his
something
bond to be
doesn't-
revoked. I just found out. I was not aware of this,
Okay.
so I'm certainly not going
We
to
got
be.
1,000 cases. I'm surprised that you're not aware of everything.
But I would
Well,
ask
this
that
is
his bond be
terrible,
revoked.
folks.
Say we have him separate now, make sure he doesn't have any contact with it from here on, and see how that
Yeah.
goes.
You've just been ordered to have a electronic monitoring device, a GPS device. So I know where you are, because you're not going to go to this house
Can he have some time to go get his stuff and move out then?
without her presence.
But he
Somebody's got to watch that.
But he would have to contact her to let her know.
You have a problem working with them on that?
No, I can do that. I'm
Yeah.
saying that,
Yeah,
but I know the rule
because
is
somebody,
on his behalf.
I expect somebody, I can trust you.
Okay, fair.
Please.
That works. Okay.
And you have to have a GPS device. You can't have contact with this lady until we can resolve this. Is this I know I'm making a big deal. It's only very disturbing. This bad things can happen under these situations. And then we got orders, conditions of bond, and the court orders that are for every case like this. that have to be followed, or else something bad happens, it will be front page. Who's to blame? And I don't think he'd be the first one on the name. He'd be in the list, but it would be someone else would be at the top. I don't want it to be me, but I expect the orders to be followed. The point is right now, I can revoke your bond. I can hold you in contempt. And I could say no bond until this gets resolved. That's what can be done right this minute, from what I know. Tell me why I shouldn't do it.
I think we need to give him a chance, Your Honor. I think he understands now. Like I said, I will set up, call his wife, let her know that he needs to get his stuff. We'll set up a time for her not to be there to get that stuff in. You were living with your mother at one point.
I
What do you have
want
in place to?
you got a week. We're going to reset this in a week to find out whether there's a problem or not. And if it's not done immediately, and I didn't find out it was done by the end of the day, then you're gonna go to jail.
Okay.
That's
What by the end of the day?
my order has to be followed.
Oh, I know, but what if we can't get our stuff out today? Can we do it tomorrow? I mean,
Somebody has to, but you can't have contact with her.
we have it set up where she's out of the house at a certain time and he go get her.
Okay,
But it does have to be done by
but
today.
she's living there.
Yes, she's living. there,
Okay,
yes.
y'all got to work that out.
All right.
But I just expect it to be done.
I will, just in a reasonable.
This
amount
is
of time.
serious
Yeah.
stuff. This is.
We won't have any more contact with her, but as far as him getting his stuff, we'll have to work out a time that's convenient for everybody.
I mean, that's a serious probable cause affidavit. That alleges some very serious violence. I mean, everything was listed in there. Punching, choking, threatening with a gun. My God. Okay, we got to take this more than serious. This is deadly. I want a hearing next week. Okay, see
Please
what.
then compare for next week.
Oh,
I'll meet you outside.
wow.
Okay. Jordan,
Welcome back to my channel. And if you are new, that wasn't for you. But there are a lot of court channels out here to subscribe to. But this channel is the one that removes all of the boring mandatory stuff that is read into the record. So with my channel, you get the charge, the indictment, the deal, the plea, some of the defense, the stuff that's funny, the prosecutor's points, and finally the judge's stuff. And the best stuff is usually off the record, which is the name of this channel, the one that doesn't bore his subscribers. And now hopefully that's you. If you click that little icon there, and I promise you, my subscribers, that the time you choose to spend with me shall be time well spent. Now, on with the show.
Three cases are called 23 CR 110, first degree felony, aggravated assault, family violence.
Your Honor, there's two cases pending. That's where he's filed.
I'm not through. 23 CR 120. We got to work through these here. Third degree felony, an indictment, a third degree felony of unlawful possession of a firearm by a felon. And in that case, stand by. As the previous case, one or more prior felony convictions are alleged. So this aggravated assault in 110, it's enhanced to, correct me if I'm wrong, no less than 15.
That one, Your Honor, they're not in sequence, so it pushes it up to the.
One level. It's a first degree felony in paragraph 1 with prior felony convictions. It would enhance it to 15
Yes,
to life.
yes.
And then in 23 CR 120, it's a third degree felony with a prior conviction. So that gets enhanced if found guilty of all of that to a second degree felony punishment. And finally, 23 CR 340, aggravated assault, family violence. Again, all of these are on the same date. It looks like on or about February 8th. Yeah. 23. Is this re-indicted
Yes,
from
Your Honor.
110?
That's correct. Caused physical injury, but in this case, it was just exhibiting the weapon and threatening.
So it was also changed from a first degree to a
To a
second
degree,
felony.
yes.
So
Should be.
that's a
passed in that
second
manner.
degree felony then, but you have two prior convictions, which look like they're not in sequence, are they?
No, Your Honor.
So it's enhanced to a first degree felony. So you have a second degree felony punishment and a first degree felony punishment. Unlawful possession of a firearm by a felon and family assault. Okay, so and 110 here, that's gone. That's out of here. So that's not part of the game. What are his bonds now, please?
It's like 60 and 10, Your Honor, 60 on the aggravated assault, 10,000 on the felony.
Who set those bonds? Curiously enough.
I'd like to know, because they're woefully inadequate under the circumstances that I'm looking at with prior criminal history and the facts of this case. Here, I'm reading the probable cause affidavit, which I'm sure would have been read, but the victim says to the defendant, she was pregnant. The defendant then grabs her, pulls a gun, sticks it to her head, told her he would kill her and hit her in her stomach. It was a revolver. Police show up. She has bruising on her right upper arm, redness to her shoulder, as well as left upper arm. Then it was located and arrested. A silver revolver with a wooden grip was located in the defendant's closet, bedroom underneath some clothes. It was a loaded Taurus 38 caliber revolver. So he was booked in for unlawful possession of a firearm by a felon because he has 2 prior felony convictions. And these facts also resulted in him being indicted for aggravated assault, family violence. Anything else? What do you want to add from the state and then defense? Let me hear you.
I mean, Your Honor, again, like you said, I believe they were set way too low in this case. The state
What
would
do you
ask
ask?
that on the assault with a deadly weapon, the state would ask for 150,000 and 50,000 on the felon in possession of a firearm.
No, we would request a lower amount. We brought this to potentially we've been in jail for almost a year now. Wait.
I don't, so what's the point about that? Doesn't purge the facts.
No, it doesn't, but I was just, it's part of just the narrative to get to everything. It's just, I gotta mention
Okay,
that.
narrate.
Your Honor, we have requested set on trial. It was set for, I believe, last week. We were on a trial docket. We did not get reached for trial. This is something we intend to try and get resolved. But in the
I
meantime.
want to ask this. Defendant is not eligible for probation, correct?
Yes, correct, Your Honor. Yes.
There's a gun in his home, right? And it happens to match the firearm that was described by a complainant in another case. So let's talk about the circumstances of this case, if you want to or not. What do you say about the firearm?
Your Honor, it was found, it was not found on him. I would make the argument that there. It was not.
It was his home.
It was,
Who was he living with?
who was it?
I was in the room. It's not-
But I mean, who lives there? It's not you. Other people live there.
it's not-
Who?
Or the victim.
The victim, they were there, they were there, so. But Your Honor, that's one of our arguments is that it wasn't found on his person. There is a whole issue about character control.
Which doesn't need to be on this person, right?
No, but you still have,
Okay.
that's true. It doesn't have to be on the person, but you still have to prove the character control, and there's gonna be some issues on that. Because it wasn't his home by himself and there's some other arguments we're gonna make, but we'll make that a trial. It's not for here. But Your Honor, we just requested that we felt that this was too high, especially also we.
What about the assault of allegedly beating on a lady, which is about as ungentlemanly as it gets? The court has little tolerance for a man doing that, unless he's defending himself, of course. But I can't imagine the way I grew up, the way everybody should grow up, where ladies or should be treated like ladies. Those, I guess your story is she beat herself up to impress the police when they showed up. All right.
But Your Honor, his family has attempted to bond him out due to the fact that there is the multiple cases to bond out and the amounts he has been unable to do that. Your Honor, he is from here. He has family here. He has relatives here. Everything. Everybody's here. He has connections to the area. He's not a flight risk. There's no doubt about that. So then it comes down to the big question. People always point out the dangers of society. This is a violent crime. We understand, but this is a targeted crime. But this is not a random crime of violence. This is something coming out of a relationship.
Well, I mean, it goes against the whole idea that our American society is built around a family unit.
But
Somebody beating up, allegedly beating up on the female portion of the family unit is going to be apt to ruin that relationship and cause hostility. This, I think our moral nature is one of peace in the home, which this defendant is charged with completely and totally eradicating.
Your Honor, I think if the court would lower his bond, but add conditions in there well, whereas conditions are always in there, but no contact with the victim, obviously stress that. If the court wanted to add a ankle monitor or some other monitoring device to help prevent that or to monitor that. But we would request that it's come down to a lower amount in the range of 20,000. I believe 60,000 based on these facts is high.
They're $100,000 in each case. These are atrocious, but his criminal history especially, he has no room for error. But to allegedly be beating on the family, a family member, and also being charged with a firearm, which has gotten him in trouble in the past. He's a felon, and that is disqualifying him from his privilege and right. And I don't find that to be unusual, unreasonable under this fact situation and his criminal history. Also, if he does post a bond, he must have, he will be placed on home confinement, not the victim's home or the complainant's home, some other place that you are going to live. And you must have a GPS and can only leave home for certain necessities that the court would describe and spell out when and if you are bonded out. Let's set this for trial. Is that what we're doing?
It's already been documented.
Let's try to get this as soon as possible.
sir.
And the defendant is ineligible for probation. All right, so let's move forward on these things.
If you like my selection and how I edit out the boring parts, please like and subscribe and become a subscriber of mine and some very fat cats. If you would like to check out a selection of my episodes, please click on and save the playlist on screen now to your YouTube. And I'll get to feeding this cat and hopefully not lose another finger in the process.